The next case is Property Junkie LLC for City of Akron Department of Neighborhood Assistance et al. Each party will have 15 minutes to present their argument. Counsel, how long would you like to reserve for rebuttal?
5 minutes, please.
All right, very good. Court will note the 5 minutes. I will attempt to, please look at that top circle up there. That's the time we'll be using for you, and about Appellee, or that middle circle when you come up. I'll try to let each of you know there's about a minute left in your time. Your initial time for you, and your rebuttal time I won't, and then for your time. When you do, I'll try to let you know there's a minute left in case you're not looking over there. The arguments are being recorded. When you present your argument, please make sure you come up to the podium, introduce yourself, stay behind the podium and speak loudly with both video and audio supporting you. I don't think anything's going to apply in this case, but if you had a child, minor, or victim, please make sure to refer to them by initials rather than their actual name. With that, the court read your brief and ready to proceed whenever you are.
Thank you, Your Honor. May it please the court. My name is Stephen Hanadel. I'm the attorney for the Appellant Property Junkie LLC. The first question the court has to address is whether Revised Code Section 2505.04 allows for a late appeal. We feel it does, as long as the party asks for leave. At that point, it becomes discretionary upon the court whether to accept the appeal. And I know, and as far as like the 30-day time frame, that operates more as a safe harbor to where if someone invokes their right to an appeal by filing a notice within 30 days, that just cements the court's jurisdiction to where the court cannot deny jurisdiction to hear the appeal. But if the party has passed 30 days, then it becomes discretionary. So from a practitioner standpoint, it's still incumbent, it's still much better, the party is much better off filing within the 30 days. However, if they're past the 30 days, if they can provide a good reason as to why they're late, then it's up to the court to decide whether they want to accept jurisdiction or not. So I think the court here needs to address that question first. And as far as the the argument,
have the cases that have looked at this question indicated that the need to appeal in 30 days is jurisdictional?
I didn't quite catch the question.
Is that need to apply within 30 days, that a jurisdictional requirement to grant the court subject matter jurisdiction?
I think the party would have to ask for leave. So it's like and I think that's where ultimately, let's say in cases where a criminal defendant filed a late appeal, I think it ultimately still comes from the same statute of 2505.04, where if a criminal defendant filed a notice of appeal past 30 days, he asks for leave, and the court grants it, then the appeal goes forward. And so that ultimately comes from the same statute here in a civil matter. So it's not, the 30 days is ultimately a safe harbor deadline. It's not an absolute like, oh, if you don't file it by then, you can never appeal. It's just now, the problem for a party if they're past 30 days is that they're subject to the discretion of the court at that point, which is still not a position you want to be in, but it's not an absolute bar. And so, like I said, in the late appeals for criminal cases, it comes from the same statute. And in the other cases that are out there in the case law, where in such as cases like this, where a party files a late appeal, in those cases, those parties did not ask for leave. They never asked for leave and never asked for that permission from the court. Say, hey, we know we're late. Can you still let us in anyway? They didn't ask that question first, and so the courts look at it like, well, you filed a late appeal, so sorry, out you go.
Can we really determine anything from those cases because they may not have asked for leave because they read the statute that they don't get leave?
Well, the statute does make reference to leave.
I mean, in these circumstances.
You have to look at the entire section. The statute, the section, refer to each other, but I believe it's 250507 says an appeal must be perfected unless otherwise provided by law, and then 250504 states if a leave to appeal from a court must first be obtained, the notice shall be filed in the appellate court. Now in this case, the common police court because it's an administrative proceeding, but the statute does reference leave. Now it's not further elaborated elsewhere, but I feel that does open the door for leave to be obtained, and again, I think in criminal cases, it's ultimately from the same authority because, both whether they're cases criminal or civil, the statutory authority on appeals come from 2505 in the revised code. So in 250502 talks about what the final appealable order, and then, and on and on. So the statutory scheme does allow for a late appeal as long as a party asks for leave. And the problem in the other cases cited by the appellees in this case is that, yes, there were plenty of cases where somebody filed a late appeal, it got thrown out because it was late, but when you read those cases in their finer details, those parties did not ask for leave, they didn't ask for permission. So once we get past that, I do feel that my client had a good reason for being late, albeit I know it was a year later, but the record provided by the city of Akron in this case showed that she never got proper service of the notice for demolition. And when the certified mail green cards was never signed by her, and it just bounced back to the city, and then the city stamped, received, saying that they got it, but there is not sufficient proof in the record that my client was ever duly served.
Well, if we get to the merits, she never did indicate the new change of address. She never filed her change of address. So they sent the notice to the last known address, right? That was in the.
They did send it to last known address at the same time. Once the city saw that she wasn't signing it, that there's a question as to whether she's getting this, they have to do their due diligence before they resort to publication. They have to do their due diligence to see where else she may be. And a simple search of the Summit County Fiscal Office would have shown that she purchased a property up in the northern part of Akron, up on Woodland Drive, and they could have searched her there. The Secretary of State record shows that she's the organizer and statutory agent of the LLC.
How did you determine that was where she physically resided or the business resided?
That.
How do we determine from the record that the address that you're advocating for was the address that she physically resided in or her business? I mean,
she swore an affidavit.
Right, I understand, but how would the city know that? How would the city know that this address, just because she purchased a property, was a place that she should be served?
This is where I'm arguing the city did not do its due diligence.
Yeah, but I'm asking you is what, I'm sorry, I'm not asking it properly. What I'm asking you is, if they've done their due diligence, how could you have determined that that was the proper place to serve her?
Because under the Secretary of State records, she was the organizer and the statutory agent of the LLC on the Secretary of State record.
And that is on the Secretary of State is her address?
The old address was on the Secretary of State website.
Saying, yes.
And that's where they attempted to serve her. That's where they first attempted to serve her. But however, when that did not work, they did not exercise any due diligence to see, well, maybe she moved somewhere else and just didn't update the record with the Ohio Secretary of State. But once they know that she is the person that is the organizer, is the owner and the statutory agent of the LLC, all they got to do is look for her personally. And there are also public records databases as well. I don't know exactly as far as all the city's resources, other than just Google. But the Summit County Fiscal Office would have yielded that she purchased her current residential property in the northern part of Akron in 2020. So,
and that's what I was getting at. What is in the record that we can determine that the city should have known that the address that you're advocating for was her actual residential address that she should have been served at?
It was in her affidavit, and I think if this court has a question about that, then I think it has to just be remanded back for a hearing with the trial court. I mean, functioning as an appellate court in this case, okay, to do a fact-finding hearing to make that determination. But as far as there's nothing in the city's records as far as what the city provided to the trial court in this. There's nothing in there about where her current address is. It's simply from her affidavit, and I can't remember if I attached a Summit County Fiscal Office printout of her residential property or not. I don't recall at the moment, but there is case law too about the due diligence requirement before serving by publication. A party attempting service has to, they just can't give up too easily once the first attempt of service fails. they have to try to locate this person and actually get to that person wherever he or she may be before they resort to publication. And so they're...
About a minute left in your time, council, before rebuttal.
Okay. Just see what other points I may want to make. And like I said, and I'll just wrap up before I go to rebuttal. Once the court determines that leave is permissible under the statute, then the question then shifts as far as whether the trial court abused its discretion in denying leave, and I feel that it did, because the record indicates that my client was not duly served with the demolition orders. So I'll reserve my remaining time. Thank you.
5 minutes for rebuttal.
Good morning, Your Honors, and may it please the court, I'm Jack Corrigan on behalf of the City of Akron and its housing, or its Department of Neighborhood Assistance and its Housing Appeals Board to urge this court to affirm the judgment below. Now, it's one thing to make a mistake and miss a case or miss a change in the law. It's another thing entirely to ignore a decades-old massive body of law that is contrary to the point that a party is trying to make. And it's entirely different to propose to a court, to the trial court below and to this court, to make a ruling contrary to that massive body of law. And that's what's happened here. And as a consequence, and with apologies, I'm going to have to use the second worst F word that one can bring to a court. And that is that this is a frivolous appeal from a frivolous appeal. And why is it frivolous? Because there is a mountain of controlling authority regarding administrative appeals, and that mountain of controlling authority holds that a trial court acting as an appellate court in an administrative appeal under revised code chapters 2505 and 2506 patently and unambiguously lacks subject matter jurisdiction, getting to Judge Stevenson, your question about its jurisdictional nature, to entertain an administrative appeal that has been filed and has been delivered to the administrative body more than 30 days after the administrative body has entered its final order.
Now, let me ask you, I'll stop you right there. We don't have subject matter jurisdiction if somebody files something over 30 days.
That is correct.
Yeah, that's what I was just going to say. But we can acquire jurisdiction in certain cases if there's a statutory procedure for that. Okay. And so he's arguing, I think, that the same procedure applies here. So both of you could be right.
Actually, no, because the overwhelming body of the law that we've had, all the decisions, some even going back to 1922, where we have subject matter jurisdiction and administrative matters are granted only by statute. 1955, which supports, that's the Richard versus Industrial Commission from the Ohio Supreme Court, that supports the proposition that I just articulated, that yes, there are some statutes that will permit leave to file a delayed appeal beyond a 30-day appellate deadline. They do not apply to administrative actions. They apply, for instance, there's a specific provision in the Rules of Appellate Procedure. It's App.No 5. It applies to criminal actions, to juvenile delinquency actions, and to serious youthful offender actions only. Instead, App.No 14 specifically says that no appellate court has the ability to extend the filing deadline in any case. So that is where there is a limited ability to file a leave to appeal. Statutorily, there's also a limited ability to file a requirement for filing a motion for leave to even file an appeal or any other case for people who have been declared by a court to be a vexatious litigator. Those people must always, regardless of the circumstances, if they have been so ordered in the order declaring them vexatious litigators, they must seek leave. Even if their appeal or their case is otherwise timely. And I take issue with the idea that there is a safe harbor for any kind of appeal or any kind of case, that all one has to do is ask and it shall be given to you. Because the law, this is even in one of the cases that my opponent cites, this is the Centorbi case, that statutes of limitations, for instance, serve important public policies. And so we have statutes of limitations that forever cut off a litigant's ability to bring their suit. We have adverse possession, which is a long-standing principle that holds that if a person, a property owner, does not pay attention to what is going on in their property, they could eventually lose title to that property if they allow a condition to go on that's adverse to their ownership interests over a course of 21 years.
I appreciate your argument that it's jurisdictional. Let's say, however, that conflicts with some form of a due process concern. For instance, the administrative body makes a decision after the hearing. It doesn't mail it to anyone, doesn't give it to anyone, just sits it on there, just announces it, puts it on their docket, 3rd day goes by, and then they think, oops, we forgot to mail it, and then they mail. Is there any remedy for a property owner or person in that circumstance to have an appeal?
Well, in that circumstance, the order that was issued would not have been properly entered. And so therefore the 30 days would not have started to run, because the deadline, an administrative order becomes final and appealable once it is entered, okay? And it is from that entry point that the 30-day deadline begins to run. And an administrative order is entered not when it's served, not when it is received by the property owner, but upon either it's being sent by mail, again, not received, posted at the property, and that's backed up by U.S. Supreme Court precedent from 1982, okay? And under our Housing Appeals Board, regulations, which are in the Akron codified ordinances, it could potentially run from the date that it's published in the Akron Beacon Journal. So,
my recollection in this case, does the record show they posted it at the property?
Yes, they did. They posted it the day after it was sent by regular and certified mail. And then a couple of days after that, it was also published in the Beacon Journal.
Okay, I'm gonna go back to Judge Stevenson's question, because I had a similar question. And I understand your argument, but let's just say that the city did, in fact, send it to a wrong address. They sent it to an address that was not the record address. Okay, so is your position is still the same, that because it was just sent, period, that means it was sent, and the property owner has to determine that somehow they have 30 days even when it's sent to an improper address?
Actually, given the fact that the Housing Appeals Board statutes or codified ordinances require that it also be posted on the property itself, that suffices to establish that the order was entered. Even if, as in this case, the property owner has never updated their address in any way that the city could have to be able to mail it to wherever she's living now.
Well, what if the property owner lived out of state? Okay, and it's not sent to the property owner at the correct address. It's very clearly not. And they post it. Again, you would say that suffices due process for taking away somebody's property?
Actually, under the Green versus Lindsay case from the U.S. Supreme Court from 1982, posting is sufficient.
Yeah, I understand, but what if we interpret in the Ohio Constitution? Do you know?
Well, this court in Roden versus Akron had actually relied upon Green versus Lindsay to indicate that posting on the property without regard to where the property owner may live or whether they're an out-of-town or absentee landlord, that suffices.
Was that where there was actual mailing notice to?
Well, yes, we had, even an unclaimed certified mail in Roden versus Akron suffices.
Okay.
And I would remind the court that the due diligence that my opponent is describing concerning what lengths he posits that the city is expected or should be expected to go to try to hunt his client down, none of that is actually required. First of all, by the Akron codified ordinances that say how we actually have an entry of an order, but also because the civil rules that he's referring to regarding notice service by publication don't apply to administrative agencies. Civil Rule 1 indicates where it's going to apply. The civil rules, in the category 4 plus 4.1, etc., those apply to service of a complaint in a court, not an order from an administrative agency. So the city was not required to hunt her down like a fugitive in order to make sure that she got it in her hand. Also, I would remind the court that in the record that was provided to the trial court when this case was filed, that there is some evidence that some of the mail that was sent to this property owner did not come back to the city as being undeliverable or not delivered. So again, the overwhelming body of law that controls administrative appeals dictates that you have 30 days to file said administrative appeal. Backing that up, again, an administrative order is final upon its entry, not upon its receipt or by the property owner or by that person laying eyes upon it. An administrative order is, a trial court has, therefore, no discretion because it has no subject matter jurisdiction. It has no discretion to forgive or alter the revised code's perfection deadline, and that is within revised code 250507, which dictates when an appeal must be perfected. I would caution the court that reference to 250508, that particular section governs only when the record must be filed. It does not expand upon the perfection deadline through its mention of leave, because again, leave can be, a vexatious litigator must obtain leave to file any kind of action, regardless of whether it's timely or not.
Counsel, before you end your argument, I just wondered too, I didn't see any record of any mediation being tried here in this court. Is that correct?
That's correct, because the procedure that we followed was that, the notice of appeal was filed a year and a month late. Along with that was the motion for leave. We opposed the motion for leave and filed a motion to dismiss. Then the litigation followed a course of opposing each other's motions, okay, including the motion for leave to amend the notice of appeal to claim that the property owners laying eyes upon the correct order suddenly pushed back the date at which that order was entered.
And in regard to mootness, I asked both sides, it has not been demolished, I assume.
It has not been. No.
Thank you.
So with the time that I have remaining, I would just like to remind the court that regarding the attempted amendment, no one can amend their way out of a jurisdictional defect. That is well established by the law, even going back through Wilmington Steel from the Ohio Supreme Court in 1991, and that had the trial court granted Property Junkie's motion for leave, this court would have been facing a very different proceeding today. It would have been facing argument facing briefing, certainly, on a writ of prohibition that the city would have brought against that action. So finally, my remaining seconds, unless the court has any further questions, the city of Akron respectfully asks you to affirm this matter. Thank you very much.
Thank you. Council, you have your full 5 minutes for.
Thank you. So all I'm asking the court to do is just simply go by the text of the statutes. And, you know, I don't think that the comparing to statute of limitations in, let's say, in civil matters is an apt comparison, because in those statutes, let's say in 2305.11, they don't allow any wiggle room for leave. You know, those are very absolute in their nature based on the way those statutes are worded. This is different. 2505.04 and then even, I believe, 2505.08 both make reference to leave. And so, and again, that's the same authority that, you know, criminal defendants rely on if they file a delayed appeal. So, ultimately, the court's jurisdiction ultimately comes from statute. It comes from the legislature. And the legislature makes it very clear in drafting these statutes that leave can be obtained. And so, now again, it's not automatic. I think my opponent tries to make it sound like, oh, just because I ask for leave, then the court must grant it. No, it's discretionary. You know, a party has to present a good reason as to why they're late, and they have to present a good reason as to why the court should acquire jurisdiction and go forward. And that's still not a great position to be in if you're a litigant, because, you know, you're at the whim of the court to decide whether your appeal can go forward or not. Whereas the better practice is to file within the 30 days, and the court can't deny your case. So, and I get, you know, when opposing counsel talks about, you know, body of case law and stuff, but there's a distinction between those cases and this case. In those cases, when parties filed their appeals late, those appeals were thrown out, not only because they were late, but the record, or at least those decisions, make no reference to that party ever asking for leave. And so just because those parties maybe did not read the statute and did not notice any distinctions and did not engage in that practice of asking for leave first, you know, it should not bind my client in this case because she asked for leave. So I get, you know, there is a little bit of a trailblazing effort here, but sometimes, you know, just because I'm trying to blaze a trail based on the wording of the statute, that doesn't make it frivolous. Just because something's been done a certain way for all this time in ignorance of what the statute says doesn't mean that that's right, and doesn't mean that a different approach can't be applied, again, based on the wording of the statute. And that's all I'm asking this court to do. And as far as on Civil Rule 1, the opposing counsel said that Civil Rule 1 doesn't apply to administrative proceedings. Well, there's a caveat to that. The Civil Rule 1 sees this to the extent that is clearly inapplicable. Okay, so that's not, so the opposing counsel's position is not an absolute position like, oh, it just never applies. It's to the extent that it's clearly inapplicable that the civil rules don't apply to like special proceedings such as an administrative proceeding. And as far as Civil Rule 4 goes, I directly, I cited this case in my brief, Ohio Supreme Court case of Sizemore versus Smith in 1983, where the Ohio Supreme Court said that, in other words, they interpreted Civil Rule 4.4 that said that allows for service by publication, and said that that rule requires taking steps in which an individual of ordinary prudence would reasonably expect to be successful in locating a defendant's address. Well, today, with the age of the internet, it doesn't take much effort to go like on the Summit County Fiscal Office website, plug in the person's name, and see if they own any property, which they can be found, or just any other public record databases that are out there, being able to locate where they may have moved to. There could be voter registrations are often online these days. There's a lot of tools with the internet to be able to locate people in varying degrees. So the city just did not exercise their due diligence. Once the mail bounced back from my client's old address, they just decided, you know what, we're just gonna go publication, and they didn't make any further efforts.
So I do want to just ask you, what was the nature of the business?
The nature of the business? She acquires properties in an effort to, old property that are needed repair, try to acquire them, for cheap, and whether it's
So they might have found, if they did that search, other properties, because the nature of the business was to buy up properties and resell them?
I mean, as far as serving her at other properties at the LLC?
Yeah. I mean, what is the extent of the due diligence that would be required? So you go online, you see, I mean, this goes to Judge Carr's sort of line of questioning earlier about what's the end there? What would be satisfactory? Say there's 20 properties with her name on it.
Ultimately, they would know from the Secretary of State records that my client was the organizer and the statutory agent. And serving the statutory agent is what constitutes service on the LLC. So she's both.
No, I understand what you're saying there. I'm just saying, how would they know? First of all, the Secretary of State's office had that address where it was sent, right, by regular
Correct.
mail and certified mail. But if you're saying they could have found out that she moved by just looking at a property that she bought, and the nature of the business was that she bought properties, how would she know? They know that was her residence, or how far would they have to?
Well, the
Go down
house,
the road.
well, the house that she bought was in her own personal name. It wasn't the name of the LLC. So the house where she lives in right now in North Akron, that was in her personal individual name, individually titled. It was not titled to the LLC. So I think, any reasonable interpretation would be that that's where she's living. Otherwise, if it were business related, it would be in the LLC.
Okay.
And also the house that she lives in, it's in a nicer, newer neighborhood that was recently developed in the past decade. So I think one can reasonably construe that she's probably living there. I know that's not always the case, but.
And you think that would be the responsibility of the city to do?
As what the Ohio Supreme Court said in Sizemore versus Smith in 1983. So that's where I'm getting the authority from as far as the city's obligations.
Thank you, I really appreciate it.
Thank you, that your time is up.
All right, thank you.
And I know the time is up, but I asked the city and they said that no mediation was attempted. Is that something that both parties would consider?
I'm not against it.
Okay, she says no. Okay, thank you.
The court will take the matter under advisement and issue a decision in due course. So that decision is agreed to be mailed to you by the clerk of court and also available on the Ohio Supreme Court's website.
Thank you.
With that, I want to thank you both for your presentations and behalf of the court.
Thank you.